Okay, hi guys. Today we're gonna talk about the very important current awareness topic which was there in the news in the year 2019-20. The topic is related to the abrogation of Article 370 of Constitution of India. Now, this news came in the month of August 2019, and it went on to further discussions. It was contradicted. It was supported. So we're gonna talk about what happened in that particular news. Now, firstly, that the Article 370 of Constitution of India, it talks about guaranteeing the special status to the state of Jammu and Kashmir. Now, what does that special status means over there? So, under the Article 370 of Indian Constitution, the state of Jammu and Kashmir can make its own constitution, and for the fact they had their own constitution, and then they can make their own laws with respect to the state's residents, and then any citizenship, or perhaps ownership of any property or any fundamental rights thereon. Then, it also can prohibit the citizens of other states to actually acquire or buy any property in the state of Jammu and Kashmir. And then, in case of any financial emergency, the center cannot intervene in the state's functions. So these were some special rights being given to the state of Jammu and Kashmir by way of Article 370 of Indian Constitution. Now, in the August 2019, the center has abrogated the Article 370, which means that the special status which has been given to the state of Jammu and Kashmir has been repealed. Now, the point is that how it happened. So there were some nuances, there were some intricacies of the law which were being addressed thereon, and in order to make this particular thing happen. Now, firstly, we need to see some interplay between the articles of the Indian Constitution. So, firstly, we had Article 370, uh, as we talked about, which actually guarantees the special status to the state of Jammu and Kashmir. Then we had Article 370 subclause 3, which is kind of giving some ways to or procedure to amend the Article 370. And then we had the Article 367, which is giving some guidance on interpretation of the Constitution of the provisions of the Constitution of India. Now, let's see how things went upon. So, firstly, the very important article, which is Article 370 subclause 3, it talks about that how the Article 370 can be amended. So, it says that the Article 370 can be amended by the concurrence of the Constituent Assembly. A Constituent Assembly is the assembly which makes the Constitution. So, when the Constituent Assembly is in concurrence with the provisions, then they can actually amend the Article 370. Now, the point over here is that the Constituent Assembly of the state of Jammu and Kashmir, when they actually pass the Constitution, they ceases to exist. So there was no Constituent Assembly at this point of time. Now, so that was the issue all about, because at the time of abrogation in the year 2019, there was no Constituent Assembly of the state of Jammu and Kashmir, and as we have seen that the Jammu and Kashmir had their own constitution. So this was the problem which was being faced by the center in actually interpreting this particular article. But then came in the play of Article 367, which actually gave the guidance of reading and interpreting the provisions of Constitution of India by the President of India. Now, by the virtue of this particular article, the Governor of Jammu and Kashmir, actually under the delegation of the President of India, has actually reinterpreted this particular uh, provision, this particular article of 370 subclause 3. Now it says that the expression Constituent Assembly of the state in the Article 370 subclause 3 shall be read to mean Legislative Assembly of the state. Now, as we have seen that there was the Constituent Assembly of the state ceases to exist in the state of Jammu and Kashmir after passing on their own constitution. Now, there was the Legislative Assembly, which is the state's assembly. So the governor gave it an interpretation that because there was no constituent assembly in the state, therefore we can take it as the legislative assembly thereon. Now, so this is the new interpretation which has been given by the governor of the Jammu and Kashmir. So now, if you're gonna read with the new interpretation, it can be said that if the Article 370 can be amended by the concurrence of the Legislative Assembly, so this Constituent Assembly can be changed to the Legislative Assembly as the new interpretation. Now, so during 2018 and then 19, the State Assembly of Jammu and Kashmir was been dissolved on some because of some issue and the uh, non-stability of the government. So it got dissolved by the governor on November 21st of 2018. Now that means after there's no legislative assembly in the state, and thereafter the president rule is applicable. Now, as per the president rule, the governor Satyapal Malik was heading the state particularly. Now, in case of absence of the legislative assembly, all the legislative powers are being incorporated to the governor. Now, then, because of the virtue of this particular situation, the Satyapal Malik became the legislative assembly of the state. So now the governor is himself is the legislative assembly of the state. Now, so thereon, in the August 2019, specifically 5th of August 2019, the President of India, in concurrence with the Jammu and Kashmir government, promulgated the Constitutional Order 2019. So the President of India, by way of Governor of Jammu and Kashmir, has promulgated the order of Constitutional Order of 2019, which stated that now the Indian Constitution will be applicable in the state of Jammu and Kashmir. Now, what does that mean? So it means that the provisions which were there applicable in the constitution of the JNK are held to be null and void, because now there is superseding constitution, which is the Constitution of India, which has been applicable in the state of Jammu and Kashmir. Now, by that way, the Article 35A was also scrapped. Now, Article 35A, it gives the it guarantees the residential status to the citizens of JNK, and gives some property rights to the citizen of JNK. So we're gonna see the implication later on. So this was also scrapped by the fact that their own constitution, which is the Constitution of JNK, has been taken over by the Indian Constitution. Now, so after this abrogation, there were some implications. Now, so abrogation has been made by within the scope of the constitution. Now, so what were the implications of the this particular abrogation? Now, it says that there was a complete applicability of the Indian constitution in the state of Jammu and Kashmir. That means that they don't have now they don't have their own constitution. The Indian constitution is applicable over there. So the special status has been repealed. Now, by way of this abrogation, the state of Jammu and Kashmir cannot have their own separate flag. So, by going by the fact that they had their own constitution, they had their own lawmaking powers, they had their own flag. So, as you can see, the flag on the right hand side, which is red in color, was their own state's flag. So now they can't have this particular flag. So Indian flag will be hoisted in the state of Jammu and Kashmir. Now, third implication was that earlier, as per the Constitution of JNK, the tenure of the state assembly was 6 years. But now, because now the Indian Constitution is applicable over there, the term has been reduced to 5 years now. So when the state government has been elected, their tenure is been fixed to 5 years instead of earlier 6 years. Now, fourth being that before the applicability of the Constitution of India, there was they had their own penal code, which is named as Ranbir Penal Code. Now it has been replaced with the Indian Penal Code. So all the provisions, substantive provisions as well as procedural provisions related to the penal code will be applicable of the which is applicable in the entire Indian territory, and not just the Ranbir Penal Code, which was applicable in the state of Jammu and Kashmir. Now, the fifth implication was that the provisions related to the state's emergency can be applied in the JNK as well by way of presidential rule. So earlier it was not possible that the center can intervene in this function, as in similar in case of financial emergencies. So now, because the Indian constitution has been applicable, these both articles can be easily applied in case of any state emergency or the financial emergency. Now, another implication was that the quotas which were passed by the center is duly applicable in the state with respect to the higher education institutions or the education institutions or the state government jobs. So everything which has been categorized. So we have some categories of the scheduled caste, the OBC, the scheduled tribes. So all of these quotas are applicable in the state of Jammu and Kashmir here onwards. Now, seventh, being that the people from the other state can acquire the property and have the residence rights in the state of Jammu and Kashmir, which was earlier been prohibited. So, by way of Article 35A, these rights have been prohibited. And now, since they have been scrapped, the people of other states who are domiciled in the other states than the JNK can actually buy the property there and have the residence rights. Now, last but not the least, there was some provisions in the JNK constitution that if the women who is domiciled in JNK marries someone who is outside the state, then she may have to give up their own her own rights in the properties which are located in the JNK. Now, because now the Indian constitution is superseding the JNK constitution, this particular provision have been invalidated. So now there is no such implication of marrying outside the state. So this is all about the article, the abrogation of Article 370 in the which was there in the news. So please let me know if you have any queries. Thank you so much.